Hello and welcome to Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every day at 8 a.m. Eastern Standard Time. Let's move on to question number 1. A federal statute prohibits the sale or resale in any place in this country of any product intended for human consumption or ingestion into the human body that contains designated chemicals known to cause cancer, unless the product is clearly labeled as dangerous. The constitutionality of this federal statute may most easily be justified on the basis of the power of Congress to A. Regulate commerce among the states, B. Enforce the 14th Amendment, C. Provide for the general welfare, or D. Promote science and the useful arts. Take 10 seconds and choose the best answer now. Now, if you chose option A, which I hope you did, you'd be correct. Regulate commerce among the states. The Commerce Clause grants Congress the power to regulate the channels and instrumentalities of commerce and other activities that have a substantial effect on interstate commerce. Congress is permitted to regulate intrastate activity only if the intrastate activity is economic or commercial activity that there is a rational basis for concluding that the activity in aggregate substantially affects interstate commerce. Here, the sale or resale of the product in question is commercial activity. Even if the product sale or resale occurs solely intrastate, Congress can still regulate this commercial activity by requiring the product to be labeled as dangerous because the activity in aggregate substantially affects interstate commerce. As such, the constitutionality of this federal statute may most easily be justified on the basis of the power of Congress to regulate commerce among the states. Question number 2. Dalton is on trial for burglary. During cross-examination of Dalton, the prosecutor wants to inquire about Dalton's earlier conviction for falsifying a credit application. Which of the following facts concerning the conviction would be the best reason for the trial court's refusing to allow such an examination? A. Dalton was released from prison 12 years ago. B. Dalton was put on probation rather than imprisoned. C. It was for a misdemeanor rather than a felony. Or D. It is on appeal. Take 10 seconds and choose the best answer now. If you chose option A, Dalton was released from prison 12 years ago, you'd be correct. All convictions for false statements, perjury, forgery, etc. are admissible to impeach a witness, whether felony or misdemeanor. Under the federal rules of evidence, convictions more than 10 years old from the date of the conviction are inadmissible unless the offering party shows that its probative value, supported by specific facts and circumstances, substantially outweighs its prejudicial effect, and the proponent gives an adverse party reasonable written notice of the intent to use it, so that party has fair opportunity to contest its use. In this case, Dalton was released from prison 12 years ago for falsifying a credit application. Because Dalton's conviction is more than 10 years old, here especially given the fact that he was released 12 years ago, so his conviction is at least 12 years old. Now, if we look at the other options, B through D, you'd notice that they're in fact not particularly relevant. B, Dalton was put on probation rather than imprisoned. The fact that someone is not in prison but instead placed on probation does not negate the fact that there was in fact a conviction, and as a result, the rule would still lie. C, it was for a misdemeanor rather than a felony. The rule does not distinguish between felonies and misdemeanors, just that this was for a false statement. Now, the interesting one is D. While you would assume that if a matter is on appeal, the conviction would be questionable. That being said, until the appeal is in fact completed, the conviction would in fact still stand. That being said, I find it very difficult that there would be an appeal 12 years later, or 12 years post a conviction, and more importantly, subsequent to the release of the individual. So as a result, B through D would not be appropriate responses, and A would be the only appropriate response. Question number 3. While driver was taking a leisurely spring drive, he momentarily took his eyes off the road to look at some colorful trees in bloom. As a result, his car swerved a few feet off the roadway, directly towards Walker, who was standing on the shoulder of the road waiting for a chance to cross. When Walker saw the car bearing down on him, he jumped backwards, fell, and injured his knee. Walker sued driver for damages, and driver moved for summary judgment. The foregoing facts are undisputed. Driver's motion should be A, denied because the record shows that Walker apprehended an imminent harmful contact with driver's car. B, denied because a jury could find that driver negligently caused Walker to suffer a legally compensable injury. C, granted because the proximate cause of Walker's injury was his own voluntary act. Or D, granted because it is not unreasonable for a person to be distracted momentarily. Take 10 seconds and choose the best answer now. If you chose option B, denied, because a jury could find that driver negligently caused Walker to suffer a legally compensable injury, you'd be correct. To establish a prima facie case for negligence, remember, you must prove a duty, breach of that duty, causation, and damages. The duty of care is a legal duty requiring the defendant to act according to a certain standard to protect a plaintiff against an unreasonable risk of injury. A duty of care is owed to all foreseeable plaintiffs, and the extent of this duty is determined by the applicable standard of care. The basic standard of care is that of a reasonable person of ordinary prudence in the defendant's position. Here, a reasonable person of ordinary prudence in driver's position would have probably kept their eyes on the road instead of looking at some colorful trees in bloom. Walker was standing on the shoulder of the road waiting for a chance to cross. So Walker was clearly a foreseeable plaintiff. Walker was injured. He jumped backwards to evade driver's swerving car. A jury could reasonably conclude that taking his eyes off the road, driver failed to exercise reasonable care to protect Walker against an unreasonable risk of injury. As such, driver's motion for summary judgment should be denied because a jury could find that driver negligently caused Walker to suffer a legally compensable injury. Let's look at the other options. A, denied because the record shows that Walker apprehended an imminent harmful contact with driver's car. In fact, I'm not certain why that would be a basis to deny this claim. In fact, it would seem a basis for exacerbating the claim. Now let's look at C. Granted, because the proximate cause of Walker's injury was his own voluntary act. In fact, that is incorrect, and simply because a person leaps to avoid danger does not in fact mean that they are now liable or that contributory negligence comes into lie. Finally, D, granted because it is not unreasonable for a person to be distracted momentarily. The argument here would be that the law clearly states that one should not text and drive, one should not use a computer and drive, or many other things, cell phone and drive. These are all things that a reasonable person would not do simply because we acknowledge that it would cause risk of injury to the general public. As a result, we have laws in place to stop people from doing such behavior. So clearly, the law already acknowledges that a person who does not pay attention when they're driving is behaving unreasonably based on the significant amount of legislation around this exact area. Okay, question number 4. Suspecting that Scott had slain his wife, police detectives persuaded one of Scott's employees to remove a drinking glass from Scott's office so that it could be used for fingerprint comparisons with a knife found near the body. The fingerprints matched. The prosecutor announced that he would present comparisons and evidence to the grand jury. Scott's lawyer immediately filed a motion to suppress the evidence of the fingerprint comparison to bar it from consideration by the grand jury, contending that the evidence was illegally acquired. The motion should be A, granted because if there was no probable cause, the grand jury should not consider the evidence. B, granted because the employee was acting as a police agent and his seizure of the glass without a warrant was unconstitutional. C, denied because motions based on exclusionary rule are premature in grand jury proceedings. Or D, denied because the glass was removed from Scott's possession by a private citizen and not a police officer. Take 10 seconds and choose the best answer now. If you chose option C, you're doing well and congratulations, denied because motions based on exclusionary rule are premature in grand jury proceedings. If a defendant's constitutional rights are violated in connection with a criminal prosecution, the exclusionary rule, a judge-made doctrine, requires the exclusion of all evidence obtained in violation of such rights and all derivative evidence as fruit of the poisonous tree. The exclusionary rule is not applicable to grand jury proceedings, however. In this case, Scott is seeking to suppress the evidence of the fingerprint comparison to bar its consideration by the grand jury based on the exclusionary rule. However, the exclusionary rule does not apply to grand jury proceedings, so our analysis, in essence, stops there. Therefore, Scott's motion should be denied because motions based on the exclusionary rule are premature in grand jury proceedings. If we recall also, the evidence that the grand jury is permitted to look at includes hearsay, includes a significant array of evidence that would in fact not be admissible at a later trial. The standards are different. Question number 5. Dietz was prosecuted for homicide. He testified that he shot in self-defense. In rebuttal, Officer Watts testified that he came to the scene in response to a telephone call from Dietz. Watts offers to testify that he asked, "What is the problem here, sir?" And Dietz replied, "I was cleaning my gun and it went off accidentally." The offered testimony is A, admissible as an excited utterance, B, admissible to impeach Dietz and as evidence that he did not act in self-defense, C, inadmissible because of Dietz's privilege against self-incrimination, or D, inadmissible because it tends to exculpate without corroboration. Take 10 seconds. If you chose option B, you're doing well still. Admissible to impeach Dietz and as evidence that he did not act in self-defense. Under the federal rules of evidence, any party, including the party calling the witness, may attack the credibility of that witness. Impeachment by prior inconsistent statements is evidence contradicting the testimony of the witness to undermine their credibility. It is not admissible to prove the truthfulness of the statement because it would be hearsay in essence for those purposes. Hearsay is generally inadmissible, as we recall. A hearsay exemption is inadmissible or is admissible because it is not hearsay under the federal rules of evidence. One such exemption is an admission of a party opponent, which is a statement by a party or by someone whose statement gets attributed to that party offered by the party opponent. Here, Dietz had testified that he shot in self-defense, whereas Officer Watts testified that Dietz had told Officer Watts that the gun went off accidentally as Dietz was cleaning his gun. Officer Watts' testimony clearly impeaches Dietz. Additionally, since Dietz's out-of-court statement to Officer Watts is an admission of a party opponent, it can also be offered to prove the truth of the matter asserted in that statement, i.e., it becomes not hearsay or an exclusion of hearsay. Accordingly, the offered testimony is admissible to impeach Dietz and as evidence that he did not act in self-defense. Question number 6. Frank owned 2 adjacent parcels, Blackacre and Whiteacre. Blackacre fronts on a poor, unpaved public road, while Whiteacre fronts on Route 20, a paved major highway. 15 years ago, Frank conveyed to his son, Sam, Blackacre, together with a right-of-way 25 feet wide over the east side of Whiteacre to Route 20. At that time, Blackacre was improved with a 10-unit motel. 10 years ago, Frank died. His will devised Whiteacre to my son Sam for life, remainder to my daughter Doris. 5 years ago, Sam executed an instrument in the proper form of a deed purporting to convey Blackacre and Whiteacre to Joe in fee simple. Joe then enlarged the motel to 12 units. 6 months ago, Sam died and Doris took possession of Whiteacre. She brought an appropriate action to enjoin Joe from using the right-of-way. In this action, who should prevail? A, Doris, because merger extinguished the easement. B, Doris, because Joe has overburdened the easement. C, Joe, because he has an easement by necessity. Or D, Joe, because he has the easement granted by Frank to Sam. Take 10 seconds and choose the best answer now. If you chose D, you'd be correct, Joe, because he has the easement granted by Frank to Sam. An easement is a grant of a non-possessory interest in land that entitles a person to use the land possessed by another. If an easement benefits its owner in the use and enjoyment of her land, it is appurtenant to that land. An easement appurtenant attaches to the land, not its owner, and therefore passes automatically with the dominant tenement. In this case, Frank conveyed Blackacre to Sam in fee simple. When Frank conveyed Blackacre to Sam, it was conveyed with an easement over Whiteacre. This easement through Whiteacre benefited Sam in his enjoyment of Blackacre because it provided access to Route 20. In other words, the easement was appurtenant to Blackacre. When Sam conveyed Blackacre to Joe in fee simple, the easement was attached to the land, so it passed automatically with Blackacre to Joe. Therefore, Joe should prevail because he has the easement granted by Frank to Sam. If we look at option A, Doris, because the merger extinguished the easement, we're clear that the easement is not extinguished, period. It travels and carries with the land. B, Doris, because Joe has overburdened the easement. There is no such thing. The easement is the easement, and it is for the purposes of the easement. The fact that there was development on the land and changed the volume of traffic does not destroy the easement. The easement was not based upon the limitation of use. C, Joe, because he has an easement by necessity. While it may be true that there is an easement by necessity, and that would be a different argument, the better argument here is clearly that the initial easement that was granted by Frank to Sam still exists, carries with the land, and is now currently in place. As a result, D is by far the best answer. Question number 7. Diggers Construction Company was engaged in blasting operations to clear the way for a new road. Diggers had erected adequate barriers and posted adequate warning signs in the vicinity of the blasting. Although Paul read and understood the signs, he entered the area to walk his dog anyway. As a result of the blasting, Paul was hit by a piece of rock and sustained head injuries. The jurisdiction follows the traditional common law rules governing the defenses of contributory negligence, assumption of risk, and last clear chance. In an action by Paul against Diggers to recover damages for his injuries, Paul will A, not prevail if Diggers exercised reasonable care to protect the public from harm. B, not prevail because Paul understood the signs and disregarded the warnings. C, prevail because Paul was harmed by Diggers' abnormally dangerous activity. Or D, prevail unless Paul failed to use reasonable care to protect himself from harm. Take 10 seconds and choose the best answer now. If you chose option B, not prevail because Paul understood the signs and disregarded the warnings, you'd be correct. A person is strictly liable for any harm which occurs while engaging in an abnormally dangerous activity, so long as the harm results from the kind of risk that made the activity abnormally dangerous in the first place. Safety precautions taken by the defendant are completely irrelevant. A plaintiff is denied recovery if the plaintiff assumes the risk by their conduct, such as voluntarily walking into a blasting zone. In this case, Diggers Construction Company was engaging in abnormally dangerous activity of blasting operations to clear the way for a new road. While Diggers would normally be strictly liable for any harm which occurs while this blasting is taking place, Paul assumed the risks of such harm by choosing to enter the area despite the adequate barriers and warning signs. Thus, Paul will not prevail in an action against Diggers to recover damages for his injuries because Paul understood the signs and disregarded the warnings nonetheless. Let's look at the other possible options. A, not prevail if Diggers exercise reasonable care to protect the public from harm. This actually, in fact, makes very little sense. As you would think, it's the general standard. If Diggers did, in fact, exercise reasonable care to protect the public from harm, then obviously, in fact, you would assume that would be the highest or the best protection for Diggers overall. However, given the issue of the strict liability for the abnormally dangerous behavior, A does not become the very best answer, because ultimately reasonable care does not necessarily remove one from strict liability. C, prevail because Paul was harmed by Diggers' abnormally dangerous activity. This ignores the fact that Paul, in essence, assumed the risk of walking into the property, and as a result is not a correct answer. D, prevail unless Paul failed to use reasonable care to protect himself from harm. Again, we have a misstatement of the rule. There is no reasonable care standard. Here, there's an assumption of risk standard. And whether that behavior or that walking into the land was reasonable or not, arguably could be a basis for finding whether, in fact, Paul assumed the risk. However, again, B, the assumption of the risk is without question the better answer. Question number 8. Park sued Dunleavy for copyright infringement for using in Dunleavy's book some slightly disguised house plans on which Park held the copyright. Park is prepared to testify that he heard Dunleavy's executive assistant for copyright matters say that Dunleavy had obtained an advance copy of the plans from Park's office manager. Park's testimony is A, admissible as reporting a statement of an employee of a party opponent, B, admissible as a statement of a co-conspirator, C, inadmissible because it is hearsay, not within any exception, or D, inadmissible because there is no showing that the assistant was authorized to speak on behalf of Dunleavy. Take 10 seconds and choose the best answer now. If you chose option A, you're on a winning streak here. A, admissible as reporting a statement of an employee of a party opponent. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay exemptions are admissible because they are not considered hearsay under the federal rules of evidence. Hearsay exemptions include admission of a party opponent, vicarious party admission, prior statements by a witness, a vicarious party admission, such as a statement by an employee that concerns a matter within the scope of employment and is made during the employment relationship, is treated as if the statement is made by that employer. In this case, Park is prepared to testify that he heard Dunleavy's executive assistant for copyright matters say that Dunleavy had obtained an advance copy of the plans from Park's office manager. This statement was within the scope of employment because it concerns copyrighted materials and it was made during the employee-employer relationship. So it will be treated as if it was made by Dunleavy. Thus, Park's testimony is admissible as reporting a statement of an employee of a party opponent. Question number 9. Dan entered the police station and announced that he wanted to confess to a murder. The police advised Dan of the Miranda warnings, and Dan signed a written waiver. Dan described the murder in detail and pinpointed the location where a murder victim had been found a few weeks before. Later, a court-appointed psychiatrist determined that Dan was suffering from a serious mental illness and interfered with his ability to make rational choices and to understand his rights, and that the psychosis had induced his confession. Dan's confession, nonetheless, is A, admissible because there was no coercive police conduct in obtaining Dan's statement. B, admissible because Dan was not in custody. C, inadmissible because Dan's confession was a product of his mental illness and was therefore involuntary. Or D, inadmissible because under these circumstances there was no valid waiver of the Miranda warnings. Take 10 seconds and choose the best option now. If you chose option A, admissible because there was no coercive police conduct in obtaining Dan's statement, you'd be correct. The Due Process Clause of the 14th Amendment requires that a confession be voluntary for it to be admissible. Voluntariness is determined by looking at the totality of the circumstances. However, only official compulsion will cause a confession to be involuntary. Here, Dan's mental state at the time of his confession carries no weight in the determination of police coercion. The facts do not indicate Dan's confession to murder was coerced by the police, so the confession is deemed constitutionally voluntary. Therefore, Dan's confession is admissible because there was no coercive police conduct in obtaining Dan's statement. Let's look at the other options. Admissible because Dan was not in custody. The fact that he was not in custody is irrelevant, as in fact a statement that's in or out of custody still could theoretically be used against an individual. C, inadmissible because Dan's confession was a product of his mental illness and therefore involuntary. The law does not deem the confession automatically involuntary as a result of any mental defect. In fact, The standard, as noted previously, is simply whether there was coercive police conduct. And the defense counsel will generally examine witnesses with regards to whether there was any police coercive conduct at that time. Here, the facts show us there were no coercive conduct whatsoever, and in fact, the defendant simply walked into the precinct and gave his confession. D, inadmissible because under these circumstances there was no valid waiver of the Miranda warnings. The waiver, in fact, is valid. However, where this gets a bit tricky is the fact that at the time, if we look at the facts, the defendant was not in custody of the police. He simply walked into the police station. He mentioned he wanted to confess to a murder. He was read Miranda rights or advised of Miranda warnings, and then in fact went on to make a statement nonetheless. At that juncture, he was not in fact in police custody. So as a result, the Miranda warnings may be ineffective nonetheless, or not necessary or required, given the fact that he was not in custody at the time. Although the police seemingly did follow proper protocol by advising the defendant of his warnings nonetheless. Question number 10, the last question in this grouping. Decker, charged with armed robbery of a store, denied he was the person who had robbed the store. In presenting the state's case, the prosecutor seeks to introduce evidence that Decker had robbed 2 other stores in the past year. The evidence is A, admissible to prove a pertinent trait of Decker's character and Decker's action in conformity therewith. B, admissible to prove Decker's intent and identity. C, inadmissible because character must be proved by reputation or opinion and may not be proved by specific acts. Or D, inadmissible because its probative value is substantially outweighed by the danger of unfair prejudice. Take 10 seconds. Choose the best answer now. If you chose option D, inadmissible because its probative value is substantially outweighed by the danger of unfair prejudice, you would be correct. You also ended this line of questioning on a great note with this correct answer. No character evidence is admissible during the prosecution's case in chief unless it is a sexual assault or child molestation case, or where the court has admitted evidence of victim's character offered by the defendant. However, if specific instances of the defendant's prior bad conduct are being offered to prove anything else that is relevant other than character, then the character evidence rules do not apply and evidence becomes admissible to prove a mimic fact, i.e. motive, intent, absence of mistake, etc. When considering mimic evidence, the court must always balance probative value of the evidence to prove the mimic fact and unfair prejudice of the evidence to prove character. In this case, the prosecution is attempting to introduce evidence that the defendant had robbed 2 other stores in the past. The prosecution is introducing this evidence as mimic evidence to demonstrate Decker's motive. However, the unfair prejudice of this evidence would require the court to exclude it. The fact that Decker had robbed 2 other stores would distract the jury from the current robbery, which is what is at issue here. Admitting this evidence would effectively allow the jury to convict Decker for his bad character rather than because he actually committed the robbery he is currently being charged for. As such, this evidence is inadmissible as a mimic evidence or mimic fact because its probative value is substantially outweighed by the danger of unfair prejudice. Let's look at the 3 other options. A, admissible to prove a pertinent trait of Decker's character and Decker's action in conformity therewith. This is a terrible answer because this is exactly what the rules of evidence were designed to protect against. You can't prove guilt simply because you have a history of, in essence, being a bad person or history of committing similar crimes. B, admissible to prove Decker's intent and identity. The identity portion is rather difficult here because the only way we could show identity is to show that or argue that this individual repeatedly or habitually commits such armed robberies. As a result, that would be extremely prejudicial, and the jury would be poisoned with the idea that the likelihood is this individual did commit this robbery simply because he has a history of committing such robberies already. C, inadmissible because character must be proved by reputation or opinion and may not be proved by specific acts. This misses the point in its entirety. We're not looking for character evidence. We're actually, in essence, looking for a pattern of behavior, and as a result, the evidence should properly be excluded. As always, thank you for joining us here on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every day at 8 a.m. Eastern Standard Time. Please like, subscribe, and click the notification bell so you can be updated every time we upload new content.